Public Safety, Public Protection Orders Bill, first reading.
The Honourable Judith Collins.
Mr Speaker, I move that the Public Safety, Public Protection Orders Bill be now read a first time. I nominate the Justice and Electoral Committee to consider the bill. Mr Speaker, this bill will improve public safety and save potential victims from almost certain serious harm or worse. The High Court will be able to order the detention of the most high-risk offenders under a public protection order. The new order will complement existing measures such as parole conditions, extended supervision orders and preventative detention. The bill responds to situations where an offender presents an unacceptable risk that cannot be managed through these existing measures. People must ask themselves whether they would place someone with a very high risk of imminent and serious sexual or violent offending in any community in New Zealand, let alone their own. At this very high level of imminent risk, the law runs out of options to manage these offenders' behaviours once their sentence is complete. This is reflected in the small numbers of people expected to receive a public protection order. I expect 5 to 12 orders over a 10-year period. Once public safety has been assured, the bill provides that the people detained under a public protection order will have all the rights of other citizens. Detention under the bill is civil in nature, but within the precincts of a prison, because the safety of the community cannot be assured otherwise. Some may say that the bill raises significant human rights issues. I believe this bill strikes the right balance between the liberty rights of individuals and under a public protection order and our duty to protect New Zealanders from imminently dangerous offenders. The bill is necessary, effective, proportionate and fair. The bill specifies a threshold and a test for a public protection order. The threshold requires a person has nearly completed sentences for sexual or violent offending or has been released from prison and subject to the most intensive form of supervision. The test requires that the person poses a very high risk of imminent and serious sexual or violent offending. Imminence means that the person is expected to commit a serious sexual or violent offence as soon as they have the suitable opportunity to do so. The Crown must prove 4 characteristics that give rise to the risk. I will go through each of these characteristics in turn because they are integral to the justification for continuing detention under a public protection order. First, it is an intense drive or urge to offend. Evidence used to prove this urge could include, for example, the individual's rapid reoffending following previous releases from custody. Second, it is an inability to control behaviour and emotions. This may be shown by evidence of impulsiveness and an inability to cope with or manage any form of stress or difficulties. Third is an absence of understanding and concern for the impact of offending on potential or actual victims. I would note here that all offenders in this group that could be subject to a public protection order will have had or been offered the opportunity of comprehensive treatment during their time in prison. The fourth and final characteristic is that the person experiences poor interpersonal relationships or social isolation or both. The Crown must prove all 4 of these characteristics to a high level to subject someone to a public protection order. 3 out of 4 characteristics is not enough to support an order. While these people have offended in the past, they will not be detained for their previous crimes. They will be detained because of their imminent risk of serious sexual violent offending at the time of the application. The test for the risk of imminent future offending will be difficult to meet. The bill recognises the serious implications of a public protection order. It also provides the following robust procedures for making the orders. Only the High Court in its civil jurisdiction will be authorised to make an order. Any application to the High Court will be accompanied by 2 health assessors' reports on the level of risk posed by the person. A person for whom an order is sought will have the right to independent legal advice and psychological evaluation, funded if necessary by legal aid. The Court may, of its own initiative, direct a health assessor to prepare a report. The bill includes a number of safeguards for the protection of the rights of individuals subject to a public protection order. There is ongoing judicial and independent supervision of the detention. A review panel will review public protection orders each year. The High Court will review the public protection orders every 5 years or more frequently on the recommendation of the review panel or an application by the resident. These regular reviews ensure that the initial determination of risk does not result in unjustifiable continuing detention. A regular review of the basis for detention ensures that a person is only detained when they pose risk. The measures in this bill will improve public safety by ensuring the detention of individuals who pose a very high risk of imminent and serious sexual or violent offending. I commend this bill to the House.
The question is that the motion be agreed to. Andrew Little.
Thank you, Mr Speaker. I rise to speak on the public safety, public protection orders